Senate Judiciary Committee. There's a sign-up sheet that was placed on the podium if you want to be heard on any of the bills that are on the calendar today. Make sure you sign up to be heard. I'm going to ask Senator Tillery, since you've been absent in some of our meetings lately, I guess you have a couple other things going on. The budget's already done, right?
Well, we have one amendment now, Mr. Chairman. Okay. Thanks. Based on those comments, I think we're going to have one amendment to the budget.
Open us up in a word of prayer, please.
Dear Heavenly Father, thank you so much for allowing us the opportunity to gather here together to seek wisdom of others on behalf of our state. I ask you would be in this presence now, and maybe we make decisions that are glorifying to you. In your name we pray. Amen.
Thank you very much. I appreciate the work you do on behalf of all of us in this state, and this chamber, and this body, and everywhere else. Yep. First bill on the agenda is Senate Bill 163, and we heard this bill in committee with testimony on Monday. And and by the way, we're working off 41301-2S. A substitute now brought. As you recall, we're having a discussion about how best to handle conducting criminal jury trials once the pandemic's over in our state, how to deal with statutory speedy trial demands in our state, and trying to get the right balance, making sure we can actually try cases in the correct priority of cases, make sure we're trying stuff, older cases hopefully first, but making sure also that folks can't take advantage of the statutory speedy trial legislation we currently have on the books and possibly game the system and lead to a situation where a lot of cases are dismissed. So in doing all that, I brought a substitute to you that has one change, which I think is a pretty big change. And lines 139 and lines 140, we have a sunset of June 30th, 2023. This will give us time to see how this works and see if it's necessary to go back and add this law back in, and give us time to make sure we get data that we can accurately look at when it comes to speedy trial demands and caseloads in our state as well. And so with that, that's the only change to the bill. I would ask that the committee go ahead and move this bill into rules. Before I do that, I'll take any questions from anybody on the committee. If not, we'll entertain a motion. Motion to pass Senate Bill 163 by committee substitute by Senator Tillery. The second by Senator Kennedy. Any discussion? All those in favor, please raise your hand. Any opposed? It passed unanimously. Thank you. Next bill on the agenda is Senate Bill 168. Senator Walker, the floor is yours, and let us know the LC you're working off of.
Thank you, Mr. Chairman and committee. Bring to you Senate Bill 168. I'm working off of LC 441626. Hope that's what's in your folder.
It is.
Georgia businesses have proven to be incredibly resourceful and resilient and adaptive to the COVID pandemic and the way we've had to change our way of doing business. Senate Bill 168 was brought to me by the Metro Atlanta Chamber and is supported by the Georgia Chamber of Commerce. It simply codifies the governor's executive order to allow shareholder meetings to be held virtually. So whether it's the annual shareholder meeting or a special shareholder meeting, it would be allowed to be held virtually even after the executive order expires. Be happy to answer any questions.
Senator Walker, did you want us to address the wording that we discussed, or
I would like that, yes, sir. So on line, thank you for bringing that up. On line 16, you see it says directors may determine that an annual shareholders meeting be held wholly or partially by means of remote communication. And then on line 26 has the same, I think, meaning, but it's not consistent with the wording. It says may determine that a special shareholders meeting be held solely or partially. So I'd like to make the language consistent and change on line 16 the word wholly to solely. Or if you all prefer wholly, we can do it the other way around.
Solely or wholly? Depends on which one you want to go.
So let's go with solely.
I like solely too. Okay. All right, we have a question from, no question? Any questions for the author? No one has signed to be heard on this bill. At this time, we'll entertain a motion.
So moved, Mr. Chairman, move to pass.
We have a motion to pass by Senator Parent, a second by Senator Tillery. We have an amendment.
Yes, sir.
All right, go ahead and speak to your amendment.
Mr. Chairman, I ask that we amend line 16, take the word wholly, change it to solely.
Senator Kennedy, do you want to be heard on the bill before we?
Well, it's really on Senator Tillery's amendment.
Okay, I'm on.
We'll change it the other way around.
Hold on, well, your mic number 10?
I'm sorry.
Oh, you're not a mic. You're breaking our
Shared mic, I'm
our
sorry.
protocol rules.
I think given that the second word is partially, I think perhaps the better choice of words would be wholly, not solely. That just seems, and again, I'll leave it to the author of the bill, but I think in thinking in terms of a shareholder meeting, I think describing that being conducted wholly, I don't know how you would solely conduct a shareholder meeting.
I can, Mr. Chairman, if it's okay with
And
you, I'd
those
like
of y'all
to-
that don't know, this is what judiciary is all about. So
like to amend my
solely or
motion.
wholly or partially. But Senator Tiller, do you want to be recognized?
Yes, Mr. Chairman, if you don't mind, I would like to amend my motion and instead strike the word solely on line 26 and replace it with the word wholly for the purpose of creating a committee substitute.
All right, so to be clear on your amendment, on line 26, you strike the word solely and replace
Yes.
it with the word wholly.
That's correct.
And that's wholly with the W.
Wholly with a W.
Okay.
I'd use an H, but
Does Ledge
WH.
Council have any comments on that, Julius?
That's, I got it, I think, Holy works.
Okay. Ledge Council likes wholly. Any more discussion on the amendment? And there was a second on the amendment, I believe, Senator Kirkpatrick. All those in favor of the amendment, please raise your hand. Any opposed? It's adopted unanimously. So now we go back to underline motion on the bill itself. All those in favor, motion for due pass as amended on LC 441626. Raise your hand. Any opposed? It passed unanimously.
Thank you. Thank you,
Senator
committee.
Walker. Yeah.
back committee substitute.
Back committee sub. Next bill on the agenda is Senate Bill 185. Senator Hatchett. You do it from up there? That's fine.
Thank you, Mr. Chairman. I guess to follow suit with the previous presentations and to quote Franklin Delano Roosevelt, I'll be sincere, I'll be brief, and I'll be seated. This is a taxpayer bill, and as a taxpayer and a small business owner, I believe that Georgia taxpayers deserve a level playing field, which is why I introduced Senate Bill 185. Basically, this prevents a tax tribunal from being able to defer to the Department of Revenue's interpretation of an ambiguous regulation. And I have the expert here with me, Jonathan Feldman, and if anyone has any questions about this, with the chairman's permission, I'd like to defer to him if anyone has any specific questions about the bill.
All right, before we do that, does anybody have any questions for the author on Senate Bill 185? Senator Tillery.
Thank you, Mr. Chairman. Senator, do you mind telling me how this would affect the Chevron case as it relates to this bill?
It would not affect the Chevron case. This actually does not do away with Chevron deference. It does away with sub-regulatory deference.
Thank you.
Any other questions for Senator Hatchett? No one signed up to be heard on this bill. Was there somebody else that wanted to speak on the bill? You mentioned somebody being here. Marshall, do you want to come up, Marshall?
Thank you, Mr. Chairman, members of the committee. I'm Marshall Guest, with the Metro Atlanta Chamber. Yeah. So thank you for the opportunity to speak in support of this bill. I believe we've submitted a letter to the committee for its consideration outlining our position on this legislation. But the important thing to know here is that this bill does promote taxpayer fairness in the state and allows the Georgia Tax Tribunal to fulfill its mission as an impartial and independent tax resolution forum. And that body, of course, was created by the General Assembly in 2012. And the other thing I think I would note for this committee is this legislation aligns Georgia with how deference is applied at the federal level, where the IRS has announced that it would no longer seek judicial deference to interpretations set forth in sub-regulatory guidance. And just the final point I would make is, we've been on a bit of a journey with this piece of legislation. This is not the first time we've been before this committee to discuss this bill. But in the interim, we did work with the Georgia Department of Revenue to come to an agreement on the language just before you now. So I just leave that with you as well. So thank you for the opportunity, Mr. Chairman, members of the committee.
Well, and I'll just state, sometimes you see a bill like this come to the floor and it seems like it's just cruising on through, right, in committee. But I was with you last year and you worked on this bill and you brought everybody to the table in the off season, and with the governor's help and the Commissioner of Department of Revenue's help, looks like you guys have got a piece of legislation that everybody's on board with. So thanks for your work on this.
Thank you.
And I was wrong. You did sign up to be heard, I now see. And Mr. Feldman, do you want to be heard as well?
Good afternoon. I'm Jonathan Feldman, a state and local tax lawyer with Evershed Sutherland. We've worked with Marshall and the Metro Atlanta Chamber on this bill. As Marshall said, I think importantly, it aligns Georgia with what's happening at the federal level, where the IRS has said they're no longer going to request deference to sub-regulatory guidance. But I'm happy to answer any questions about the bill.
All right. Any questions for Mr. Feldman or Mr. Guess? I hadn't asked that. Any questions from the committee? Senator Cowser, you're mic 4.
Thank you. I'm curious, the version last year didn't deal just with sub-regulatory deference. It was generally more broader regulatory deference, right?
It was broader last year. This is a lighter version and one that was agreed upon with DOR.
As a practicing attorney, what are your views on regulatory deference in general? You think we should continue that practice, or would you love to see this bill broadened a bit?
I mean, there are certainly issues with deference to regulations, but there is certainly an argument to be made that there's a distinction between regulatory deference and sub-regulatory deference. To the effect of when you're referring to a regulation, regulations are passed pursuant to the Administrative Practices Act. There's public comment. There's the opportunity for legislative override. But with sub-regulatory deference, there's no opportunity for that. In fact, the department often asks before the tribunal for deference to their interpretations of their regulation, and often interpretations that are not even published anywhere. It may be a litigating position, something that's unpublished. So this does away with sub-regulatory deference, whether it's written or unwritten. So to answer your question, I mean, there are plenty of arguments to do away with regulatory deference. And maybe one day you'll get a U.S. Supreme Court case that will do that, and that will probably trickle down to Georgia. But this bill aligns Georgia with how it's being done at the federal level for tax.
One more. All right, so last year our Department of Revenue, through their regulatory powers, essentially overrode the desire of the legislature on the Delta tax. You may have the fuel tax on airlines. That they would still have the power to just disregard us and interpret things in their way, and the courts, tax court would then have to give deference to the Department of Revenue even with this bill passed.
My understanding is that was not a formal regulation. I think it was a ruling or an opinion, but I don't think it was a regulation that went through the APA.
So would that be covered through this bill then?
it would be covered. It would be sub-regulatory, yes.
Right. So if that were appealed, we would not give deference to the Department of Revenue's ruling.
That is correct.
Thank you.
Any other questions? Senator Kirkpatrick?
Mr. Chair, at the appropriate time.
Eager. Anybody else want to be heard on this bill? Any other questions from the committee? Now is the appropriate time.
Okay. I would move due pass on Senate Bill 185, LC 43, 1892.
We have a motion due pass by Senator Kirkpatrick. Do we have a second? We have a second by Senator Kennedy. Any discussion? All those in favor of the motion, please raise your hand. Any opposed? It passed unanimously. All right. Thank you. The next bill on the agenda is Senate Bill 92. Did Senator Robertson get in the room yet? He was running a little late, so we're going to hold on that one. And we will go to Senate Bill 117 if the pro tem is here. Yes. Senate Bill 117.
Thank you, Mr. Chairman. I am working off LC 412622, Senate Bill 117. And thank you, Mr. Chairman and members of the committee. I'm glad to be before you today. This is an issue that has come up in my community and come up in communities around the state. This bill creates the offense of the improper sexual contact by a person in a position of trust. The background of this bill is that in my community, there was a basketball coach that, although worked for one school within the system, had an inappropriate relationship with a minor in another school in the system, and because it didn't work did not work in the particular school that child went to, the district attorney was unable to prosecute it. And what I want to try to do is close that loophole so that folks who have inappropriate relationships with minors can be properly dealt with.
Okay, Senator Lester Jackson has an identical bill that he's filed as well. Is that correct?
That's correct.
Do you know that bill number?
196.
196.
Somebody tells me.
196. Okay.
Yeah.
And is there any difference between your bill and Senate Bill 196?
Word for word, they're the same.
We have any questions for the pro tem on Senate Bill 117? No one has signed up to speak on the bills. Anybody else that wants to be heard on this bill? Come on down.
There you go.
Thank you. Thank you, Mr. Chairman, members of the Senate Judiciary Committee. I'll be very, very brief. I discussed this with...
If you'll identify yourself, everybody hasn't met you on the committee yet before.
Oh, okay. I apologize. For the benefit of all the new members of the committee, my name is Thomas Weaver. I'm a private citizen. I'm an advocate, and I come down to the state capitol on my own time, my own dime, and I advocate for things that I think that are meaningful just for me. But for the benefit of the entire committee as a whole, now that I have the current LC version that the pro tem is working off of, if it should meet with the chair's approval, I'd like to direct the committee's attention, please, to a couple of lines that I discussed with the pro tem in the hallway along with this legislative team that I think that would add merit to the bill and doesn't subtract a single iota from what the pro tem is trying to accomplish as far as a legislative standpoint. Specifically, if the committee would please go to line 238 of the bill. Under the current statutory provisions of Georgia Code Section 42-1-12, subsection A, paragraph 10, subparagraph capital C, which is already current Georgia law, the state of Georgia, by and through the General Assembly, has already prescribed that a criminal defendant whom is lawfully arrested for, duly charged with, and properly convicted of an underlying dangerous sexual offense, which was either adjudicated in the juvenile court or which resulted in only the imposition of a misdemeanor, is excused from sexual predator registration requirements. On line 238, and this may be a legislative drafting error, but that particular code section, as is codified under Georgia Code Section 16-12-100, subpart 1, prescribing for the offense of electronically furnishing obscene materials to a minor, is a misdemeanor. And therefore, because this is included in the list, it would perhaps give a criminal defendant ability to appeal if the basis for their registration was on the predicate basis of the underlining misdemeanor adjudication, should that be the specific offense that they're convicted of. If the committee would turn back just one page and go to lines 226 and 227, the Georgia General Assembly has previously created for the aggravated offense of aggravated child molestation, but if you see there, Legislative Counsel acknowledges after the comma, unless the criminal defendant was convicted of a misdemeanor, because misdemeanors are by law statutorily excluded from inclusion on the list. And again, this was discussed with the pro tem and also the Prosecuting Attorney's Council of Georgia briefly, and his legislative aide in the hall. Because misdemeanors are statutorily precluded from the list, if that language is not removed under line 238 and 239, and then on lines 244 and 245, when it says any other conduct, when the judge has this wide unilateral discretion that the legislature wishes to grant the judicature or the seated judge at trial, to clarify that not just any criminal offense but felony would be what's required based on the law as it is today. So if it should meet with this committee's approval, and if the chair should choose to allow it, I would respectfully request that this committee please consider on line 226 and 227 to delete all that language that starts with the word unless and then through the word offense, and then on lines 238 and 239 to delete those lines entirely, and then on lines 244 and 245 to insert the word felony in front of the word sexual, so that the list exactly coincides and is harmonized just strictly through a drafting as what current law already provides, and that only felonies, not misdemeanors, which I believe Prosecuting Attorneys Council and others have kind of gave a wink and a nod towards that because that's their understanding, as is mine. Only felonies can be statutorily included and not just merely misdemeanors. With that, I'll conclude my remarks. I'm not trying to direct this committee to do or not do anything. It's not stepping on the pro tem's bill in any way. I'm not going to get into the public policy as to whether or not the legislature wishes to create this new crime.
Thank you, Mr. Weaver. Does anybody have a question for Mr. Weaver? Senator Tillery.
Thank you, Mr. Weaver. Mr. Weaver, why would you not just take the unless a person was convicted of a misdemeanor offense in 226 and 227 and tag it on to 239 and then tag it on again on 245? Would that not also alleviate the concerns?
Well, Senator Tillery, if I may answer your question, I could do that in my mind's eye. I could do that with several of these different code sections because there are lesser included misdemeanors under various of these code sections. There's misdemeanor child molestation under the Romeo and Juliet law. There's misdemeanor obscene telephone contact on first strike. There's misdemeanor sexual exploitation of children under 1612-100 under certain exceptions, based also on the Romeo and Juliet provisions, as there are misdemeanors under this particular code section if you were to read through the first sections of the bill, which is also current law for the offenses of sexual assault by a person with disciplinary and supervisory authority. So, and if you wanted to go back and exempt all the different places under law where misdemeanors are already there, it would make this pages long on top of the pages that it already is. The alternative to that I posited, if it should meet with the committee's approval and if it should meet with your Cameral's approval based on the direction of the chair and leadership, is just to simply remove the misdemeanor language, the unless the person is under the aggravated child molestation. Remove the misdemeanor offense of electronically furnishing obscene material to a minor under lines 238 and 239 completely, because there's no way to be put in felony world for that, because under current law that's a misdemeanor only. And then to insert the word felony twice in lines 244 and 45 such that it reads, is a felony sexual offense against a minor or any other conduct which is a felony sexual offense as a minor, so that no matter which code section you read, whether you're an attorney or a judge or a criminal defendant or otherwise, even if you're a private citizen advocate such as myself, you would have the law would read consistently throughout the entirety of the code section that the pro tem's bill touches on here. In the past, Senator Tillery, if I may, this second or subsequent conviction under lines 234 and 242, that was language that I got the House to fix through Legislative Council last go around, the last time the legislature touched on this statute, but that slipped through the cracks, and this would just reinforce what the legislature's slowly been marching towards, which is, again, already law since the inception of the registration requirement, I believe back in 2005 or 2006, that only felonies get you caught up in that, not misdemeanors. And that would just clarify the law through and through.
Any other questions for Mr. Weaver at this time? Thank you. Appreciate your testimony. I'd like to recognize Mr. Chisholm. If you want to come up, Solicitor General out in Athens, Clarke County. Love to hear from you on this bill as well.
Thank you, Chairman Strickland, for the opportunity to speak to you here today. I'm really coming to you more anecdotally, and I hope that's okay. This bill is one that I am supportive of because of a case that I prosecuted in Athens, Clarke County a couple of years ago. It was back in November 2017. One of my victim advocates came in my office to tell me that we had just got a case that involved a teenage victim who was training with a soccer coach, and she said that the soccer coach had inappropriately touched her. And I'm going to tell you, in my brain, I'm ashamed at how my first thoughts went. I initially believed that this was probably a misunderstanding, that what soccer coach would do this as this one-touch type of a thing. So I asked for her to come in to meet with me, and we met a couple days later in my office, and I discovered that it was not just a one-touch incident, that this was a pattern of behavior that had developed over time. And in fact, she had known the soccer coach for about 5 or 6 years. She first met him in the soccer circles when he was coaching her brother. And then she became one of his players, and he had coached her team. He then opened up a local soccer facility for private soccer training, which she attended while she was in high school. While she was in high school and while he was training her, there were no issues initially. In fact, he had her become one of his babysitters that he ended up using regularly. And she got to know his kids and his wife, and it was a positive relationship. Her parents really enjoyed him. He was a very popular coach among kids, and there weren't any problems until she turned 17. And she was a senior in high school, and she had a game. She was very serious about her soccer, and she had a game where she did not play as well as she wanted. So she reached out to the defendant and asked to come in and have him help her with some of her shooting techniques. And so he had her come by, and while he was training her, it was towards the end of the session, he said, "Okay, before you leave, you're going to need to stretch." Now, she had never had him stretch her before. He had never offered this, never asked for it, whether she was a player for him or as somebody he was training. And she said, "Okay." And he explained, "Look, you don't want." "Look, you don't want to be sore for the game coming up. You did a lot of shooting tonight, and that's tough on the legs." And she would say, "Yeah, that's tough based on the muscles you have to use." So he had her lie down on her back. She had one leg prone on the floor, and then he straddled that leg on his knees, and then he took the other leg and bent it and pushed it up towards her chest area while holding the prone leg down with his right hand. She had soccer shorts on, which is the typical clothing that any soccer player that would come and train would wear. He placed his hand high up on her thigh. She thought it was a bit high. It was right up underneath the bottom of her shorts. She thought it was a little strange, but she didn't think anything more of it. Everything else seemed normal. He was talking with her the whole time. The stretching went on. Everything seemed like it was just part of the session. He had her come back again to follow up later on for another session, and the stretching happened again. This time the hand went up underneath the shorts, and his thumb went under her underwear, and his thumb was on her vagina. While he's stretching her, he's talking the whole time, and it's very normal conversation. It's about her, and it's about school, it's about soccer, it's about other teams, things that would put her mind at ease. She thought it was uncomfortable. She thought it was weird. She used that term a number of times. She's 17 years old. But this is somebody that she's known for years. She trusted him. Her parents trusted him. He was trusted individually by a number of people throughout the soccer community. She did not want to say anything to him because she thought it would be awkward and uncomfortable. So she just let it ride. She did ask a friend. She and her friend, neither of them were sexually experienced. They both thought it must be some type of accident, or he just doesn't know that he's doing it. She ends up breaking her leg not long after that, so she's out of soccer for a while. But once the leg heals, she wants to get back into soccer. So she comes back in and she starts training again. He starts doing the stretching again. He, again, runs his hand up high on her thigh, thumb under the shorts, under her underwear. Thumb is now on her vagina. She continues to go in. Everything still, he makes it seem very casual, that nothing unusual is happening. He's also texting her, and he's texting her about stretching. Next time might need to do some more stretching. You need to get more loose. Stretch and party with me. Those types of things. The text originally, months before, had been a little more business oriented. What time are you going to be here? When are you going to work out again? Those types of things. But now it's getting into the stretching, the clothes she's going to wear, those types of things. So it all came to a head in September of 2017 when she came in for a session, and this time it wasn't just his thumb that went under her underwear, it was his whole hand. And he was cupping her vagina. And then while he was doing that, this time he stopped talking. And it was just silence. And she slapped his arm, she got up, she left, and she reported it. A warrant was ultimately taken for sexual battery. And shortly thereafter, what I haven't told you up to this point is there was actually a second female, another 17-year-old, who did not know. They knew each other. They both were in the same soccer circles, so they knew each other by name and by face, but they weren't socially connected. They weren't in each other's phones. And when they were interviewed individually and separately without each other knowing about one another by the police, they gave almost identical statements about what happened in describing the stretching. So when I first get this case, I'm thinking there's no way this is a felony because the sexual batteries we get as misdemeanors aren't anything like this. It's very spontaneous usually. You're downtown Athens, we get a lot of those, usually involving some alcohol. It's a lot of times stranger on stranger, but we do get those incidents where there's two friends, maybe they're drinking, and one tries to take in the initiative and makes an inappropriate contact to take things further. Sometimes we get these cases because there's a mental health issue involved, but usually it's a one-time touching and that's it. This was different. This was a pattern of not just intentional but calculated behavior. And it was a position that he had found himself in. The defendant was in a position of trust. He knew his status in the soccer community. He knew his status with these two individuals. By the way, I did interview other female and male soccer players that trained with him. These were the only two that he had singled out to train alone. At each of their sessions, there was nobody else present. They would always train alone. And so this was not a normal part of any of the other training sessions with other soccer players. It was with these two. And he took advantage of it. And this was more than just misdemeanor behavior. This was predatory behavior that should be a felony. We did prosecute the first case to trial with a conviction. I'm not going to get into all the details about the second case due to time constraints. I know we're very busy here, but the plan had been to send the second case to the DA's office. Due to some issues that had come up after the first trial, we ended up having to keep that as a misdemeanor sexual battery. He ended up getting 2 convictions for misdemeanor sexual battery. He is now off of his sentence. And because we were not able to get a felony, he's not on a sex offender registry. And he can go right back to starting his business again if he wants and training kids again. And that is not what I'm confident Athens-Clarke County citizens don't want that. I know the families that I worked with, they don't want that. They really wanted him to be on the sex offender registry, and we tried our hardest to get there. But it shouldn't have been in our office to begin with. If he had been a coach at our victim's high school, this would have been a felony. But he wasn't her coach at our high school. He was her coach, her private coach. There shouldn't be a difference. The nature of the relationship is the same. If anything, it was a little bit more bitter for one of the fathers who I worked with who said, I just paid this guy to molest my daughter. So I'm asking for serious consideration of this bill, that you support it. It's needed. There is this gap that's in the current statute that just doesn't address this behavior. If you have children, you probably know, especially if they play sports, private sports right now is a pretty large cottage industry where there's a lot of these coaches that are out there. Travel baseball is what my boys do, and they've been a part of that. And there's a lot of opportunity for the wrong kind of adult get involved and have access to these children. And there's no hope for them for us to be able to put them on a sex offender registry if they go the way that this defendant did. Thank you.
Do you mind addressing the issue that was brought up by Mr. Weaver, or do you want to have Mr. Skandalakis come up and address that?
I'll have Mr. Skandalakis if he could.
Any
come
questions first? All right, he'll come up. Thank you.
Thank you.
I would like to get a response, if you can, on the issue raised by Mr. Weaver.
Mr. Weaver's correct. That's all I can tell you. He's right on point. It wouldn't change the substance, but he's absolutely right.
I've been seeing him since I was in the house, and a lot of times you are correct.
Yeah, and so I don't have anything to add to what he's already told y'all.
You can make a suggestion to us as the best way to
I think
this.
what he suggested was the best way to do it. Strike through the lines and just add it at the end, like he said.
Any questions, Mr. Skandalakis? Thank you. Anybody else want to be heard on this bill?
No cross? Thank you.
It's coming.
Good bill.
Did you want to say something else?
I just asked for the committee's favorable consideration.
Thank you. Any discussion on this bill? Now is the appropriate time for a motion. Move to pass by Senator Cowsert. Is there a second? Second by Senator Tillery. Senator Tillery, do you have an amendment?
Yes, Mr. Chairman. I'd like to propose the Weaver amendment.
Do you think you can say what it is? Mr. Weaver have to come back up and tell us.
You know, it may be better if he does it, but I think I've got it right. And Mr. Weaver, correct me if I'm wrong. Strike the language unless the person was convicted of a misdemeanor offense in lines 226 and 227. Strike lines 238 and 239 in their entirety. And add the word felony before the word sexual on line 244, and add the word felony before sexual on line 245. Mr. Weaver, is that? I've got the approval from the back.
And Julius, Legislative Council, did you catch the amendment?
Yes, I caught that. I think the changes on lines 238 through 239 are appropriate. The changes on lines 244 and 245 are okay. However, further down in this code section that is not captured in the language that's in this particular bill is a subparagraph C, which says that for the purposes of this paragraph, a conviction for a misdemeanor shall not be considered a dangerous sexual offense. So the code section already contemplates that only felony offenses are going to be considered within this definition. That part is just not captured within the paragraph that's in this particular bill, but it is already accounted for.
Okay, thank you. Senator Tiller, do you want to keep your amendment as it is, or you want to change it?
Mr. Tolbert, you don't think there's a problem with keeping it as it is? I understand the redundancy and the duplication.
Well, can you restate your amendment so everybody's clear on it?
I was asking a question of the legislative council. I'm sorry. Is that?
I'm sorry.
Mr. Tolbert, do you? I understand the duplicity and the redundancy, rather, is the word I think I was looking for. The redundancy and the repetition. But does the amendment cause a problem? Does the redundancy cause a problem with the code?
No, in lines 244 to 245, if you had added felony, no, it would not cause any issue.
Gotcha.
Okay. Is everybody clear on the amendment from Senator Tillery? Do we have a second? Second from Senator Hatchett. Any discussion on the motion or the amendment? All those in favor of the motion, please raise your hand. We'll back up. I got to do the amendment first. All those in favor of the amendment, please raise your hand. Passed unanimously. Now we're back on the motion. All those in favor of the motion, please raise your hand. Passed unanimously. Thank you very much. Senator Miller, I guess it's just a little Scrivener's error that we were able to address.
I was about to mention that, Scrivener's error. They come in bunches.
It's been a long day.
Thank you, Mr. Chairman.
Thank you.
Committee.
Senator Robertson, I saw you come in. Are you still here? You don't get two strides at it. You want to come on down? We have Senate Bill 92 going back on the agenda. Senator Robertson, working off LC 280205S. Is that correct?
I believe that's different than what I have. You comfortable sitting here, Mr. Chairman?
Sure.
And since I can set this stuff down and look at what you just referenced.
Get your stuff together. Let us know what LC you have.
No, sir, I'm not working off the substitute. I'm working off LC 280070. If you don't mind. I think I can slide through here, at least for a couple more years. Thank you, Chairman Watson.
Are you familiar with the substitute?
I'm trying to recall the change. I'm looking for a particular line.
Why don't you go and tell us about your bill, Senator, and then we'll get Legislative Council to address the change that was made in the substitute.
I'll do that, and let's see. If you'll bear with me 1 second, please, Mr. Chair. I sent you something. on that. Thank you, Mr. Chair. I always get concerned, especially, hearing the bill that the committee just heard, along with other bills that really bring home the pain that comes along with being a young person and the things that they have to deal with. And so I know everybody's looking at the bill in front of them, and Senate Bill 92, and it seems somewhat innocuous to some of those things. But none of us ever knew Maya Gold. And to read a portion of something that her mother wrote is, Maya made a mistake from which there's no retreat, no undoing, no return to a time before what has been done. That is where we begin to make sense of this. Maya taught us about joy, about fun, about love. She brought kindness and compassion to all she met, and for that we are grateful. And now Maya has taught us about grief, about despair, about loss, in a way we were never impacted, in no way we ever imagined. From all of this, the grief to joy, the despair to hope, we can only hope to find a middle way, a way of loving kindness, acceptance, and compassion. And the reason Maya has caused the suffering is because Maya became addicted to cough medicine. Because of our society and that constant desire for the dopamine dump and the adrenaline dump, being 15 years old is not like being 15 years old when I was a kid. So life's much, much different. So for that reason and many other reasons, we brought before you Senate Bill 92, which simply does one thing. It deals with cough syrups made of dextromorphin or DMX as it's known. Here in the state of Georgia, all we're asking is that this medication be an individual be required to show identification that identifies them as 18 years or older in order to purchase this. It also requires that if the retailer fails to do that, that law enforcement on the first offense issue a letter to the clerk and to the minor advising them that they violated Georgia law. And upon the second time that this occurs, then each of those individuals would be charged with a misdemeanor under Georgia law. It's the trade association that represents and manufactures these types of medication are 100% behind this legislation. They see the benefit of this legislation, but at the same time, they also see the danger that comes when children find these types of drugs and they combine them with energy drinks to make things such as lean and drink, purple drink, and some of the other stuff that we see on the streets today. Members of this committee here have talked in the past about the devastation within certain youth populations around our country because of this. A lot of the damage caused in our society is not always caused by heroin, cocaine, and firearms. Sometimes it's by some of the simplest things that we don't even think exist, or we as adults don't even have on our radar. So, Mr. Chair, I'd be happy to answer any questions related to anything. I do believe that on the substitute, there was a consideration made in relation to the effect the pandemic had on online sales as far as Instacart and things like that, to set up some kind of standard so that an individual who may wanted to purchase this via Instacart would be able to do so. So that thought just fell into my brain from somewhere in the back. And I believe starts on line 30. Small c Charlie. A person making a retail sale of a finished drug product containing any quantity of dexamorphin shall require and obtain proper identification from the purchaser before completing the sale, provided, however, that a person that provides online sales of such drug products for home delivery may accept a purchaser's declaration that he or she is an adult when such purchaser registers for the online sale with home delivery with the person making the sale, and such declaration shall satisfy the requirements of this subsection regarding requiring and obtaining proper identification. I think the word in there that helps a little bit is that a person that provides online sales of such drug products. Not every store would, of course, be required to make an online sale. It's entirely up to the merchant and whatever liability they would be willing to accept.
Thank you, Senator. On line 67, was it your intent to make sure that the regulation is completely reserved to the state and that you wouldn't have any other forms of government in our state regulating this as well?
Correct. So you are correct that only the state would be able to do that. And I'd be more than happy with a friendly amendment if the chairperson has such.
And I'll be happy to take any feedback from anyone else or let council, but I think you want to include county and consolidated government there as well. Julius, if we want to fix line 67 to make sure we cover any other forms of government in our state, do we need to add anything other than county or consolidated government there?
No, if you add those two, that should cover anything that's a possibility.
Okay, thank you. We have a question from, no questions. Oh, you do it. Sorry, Senator Patrick.
Oh, I'm sorry.
I thought you waved off, sorry.
No, I didn't. Anyway, I just want to be sure I'm clear about, I think I understand why you're doing this, because there are other cough syrups that have other substances that can be abused, but like codeine, promethazine, things like that. But the difference with dextromethorphan is that it's not a prescription. Is that correct?
That's correct. It is an over-the-counter product. Yes, ma'am.
Any other questions for the author of the bill? Nobody signed up to be heard on this bill. At this time, it'd be appropriate for a motion. Move to pass by Senator Kennedy, second by Senator Watson. Senator Tillery, would you like to offer an amendment on this one? Or anybody else that took notes since you weren't listening?
I'd ask the committee to consider an amendment on line 67 after the word municipality. Add, except as provided by statute, a municipality, nor county, nor consolidated government. Or actually, I think it would be read better to say a county, a municipality, county, nor consolidated. I'm sorry, man. I had too many numbers in my head today. Municipality, county, nor consolidated government may enact or enforce. So you're trying to add the words county and consolidated government to this amendment, Mr. Chairman. But the word not is causing me a problem afterwards.
I was wondering if you could just say a municipality, comma, county, comma, or consolidated government may not. I understand it's kind of funny, but
I think those are that accomplishes the purpose.
The doctor approves of that.
All right.
Okay. Are you offering that as an amendment? Wait, Julius has something.
And we're removing the word not. Is that correct?
Let's say it this way.
Let's go with this way.
Comma, municipality or consolidated government may not.
Okay. Did everybody hear that? Senator Tillery, is that your motion?
Yes, Mr.
Do
Chairman.
we have a second on the amendment? All those in favor of the amendment, please raise your hand. Any opposed? We pass unanimously. Senator Parent, do you want to be heard on the bill? I know you pushed your button. I'm sorry. At this point where it's time for discussion, Senator Parent?
It's discussion. Thank you, Mr. Chairman. I should have asked this a little bit earlier, but I missed the reason. If the author could remind me the reason that we are preempting the local governments in the legislation and through the amendment from regulating this substance?
Well, I mean, the point is I would not want any local ordinance to supersede the state law that prevents anyone from 18 or younger than 18 from purchasing this product, because the product's extremely dangerous when abused and misused is my intent.
Oh, I see. Well, sometimes, I mean, have you considered, sometimes people or legislation will allow for a floor, essentially, but not a ceiling. So like if a local, instead of preempting it fully, you're allowed to take action as a government that's more strict than what's in the state law, but not more lenient, which seems to be your concern.
It is, but my biggest, what I have found in my past is consistency throughout the state on laws and regulations seems to protect more than the confusion from going from place to place. So dealing with something like this, I just think the consistency of having it the same statewide would be easier for the citizen to understand and follow, I would hope.
Yeah, if you can ask a follow-up.
Sure.
If you, I understand that reasoning. Have you talked to any of the groups representing local governments to find out if they would have an issue with this preemption?
No, ma'am, I haven't. The individuals I've spoken with were primary individuals in public safety and the merchants associations that actually stock and sell the product.
Thank you.
Yes, ma'am.
All right, we have a motion on the table. We're at the point of discussion. Senator Jones.
Which I like the bill, but so I was just wondering, do we have a similar preemption like for cigarettes, or are you aware?
I'm not aware.
Okay.
No, sir. That's a great point. Yes, sir.
Okay,
I'm not aware.
Unless somebody objects, Senator Tillery wants to amend his amendment, and so I'm going to give him one more shot at that. Unless somebody's got an objection, we have a motion on the table. But Senator Tillery?
Mr. Chairman, I ask that we amend line 67 so that it would read specifically provided by statute, comma, no county, municipality, or consolidated government may enact or enforce an ordinance.
Any issue with this amendment? Do we have a second? Second by Senator Hatchett. All those in favor of the amendment, please raise your hand. Any opposed? Passed unanimously. Oh, sorry, 2 opposed. So we have a motion on the table, do pass by committee substitute. All those in favor of the motion, please raise your hand. Any opposed? It passed unanimously.
Thank you, Mr.
Senator
Chairman.
Robertson. All right, going back on the agenda, the next bill on the agenda is Senate Bill 10 by Senator Jones. And let's make sure we are on the same page. Give us just 1 second. Okay. Sorry, I was a little bit out of order. Senate Bill 10 may be a little further in your folder. We're working off LC 392952S. Is that what you have, Senator Jones?
That's correct, Mr. Chairman.
All right, the floor is yours.
Thank you, Mr. Chairman. Senate Bill 10 revises the penalties for land drag and drag racing. It also provides for creating unique license plates for vehicles that have been converted using nitrous or adding chips to certain vehicles. It also provides license plates for vehicles, new vehicles that are high output. And if you would allow me, I'll just step through certain provisions of the bill. Section 2 of the bill on page 2 deals with any person that knowingly promotes or advertises these illegal events on our highways and byways. And down in section B, it also deals with any person who is present in betting or wagering on these particular activities. Section 3 of the bill deals with vehicles that are in excess, new vehicles manufactured of 650 horsepower. And number 2 of section 3 deals with vehicles that are converted, that they would have to register using those unique license plates. It should be noted over on line 47 on page 3 that in addition to vehicles that are being converted, that those entities or organizations that actually convert these vehicles would have to lend their name and address, the business name and address, to the registration as well. The fines are increased, and as I mentioned earlier, the offense is raised from a misdemeanor to a higher and aggravated misdemeanor. There's also points off your licenses that are increased as well. Over on page 6, for first offense of drag racing and land drag, it goes from 4, subsequent 1, second 6, third one, of course, is 8. Over on page 7, it lists the punishment starting down on line 171. And over on the second page, the next page, page 8, it lists the first conviction being a fine up to $1,000, second offense $2,000, and third offense up to $3,000. There is a forfeiture provision included in this bill, but only for the second offense and only for those high-performance vehicles. And it's only upon conviction. And over on page 10, section 10, it carves out a separate section that only applies to off-road vehicles, and those off-road vehicles that are being driven upon our highways. Section 11 leaves off-road vehicles simply as a criminal act. And I apologize, Mr. Chairman, I failed to note that in the very first section of this bill, section 1, I named this bill the J. Mia Sanford Law, and during the subcommittee hearing, her mother was there present, who inspired me to draft this legislation with the loss of her daughter in a horrific accident that occurred in my district on Columbia Drive in DeKalb County.
Thank you, Senator. I was going to mention that the bill some of y'all on the subcommittee was heard in subcommittee. I appreciate the work you did. You took a lot of the suggestions of changes to the bill to make it better through the process. I know there also, as you mentioned, were people you had to testify at that hearing as well the committee got to hear from. But I appreciate your work on this bill. I know you also stood with the governor recently as he announced legislation in the House that's also going after the same industry, if you will, that's happening around not just in Metro Atlanta, but around the state right now. So I appreciate your work on this. Any questions for Senator Jones? We have Senator Parent.
Great. Thank you, Mr. Chairman. Thank you, Senator.
Thank you, Madam Chair.
I have not delved into the governor's bill yet. I'm sure it's a long answer, but could you briefly summarize for me how your SB 10 differs from what he's proposed?
Absolutely. Be glad to, Madam Chair. The governor's bill statutes kind of mirrors those of the DUI laws. He imposed punishment. The first punishment is suspension of license during the first offense for 1 year. After that is a 3-year suspension, and the third and subsequent violation is a 3-year. He also raises the penalties from a misdemeanor to a high and aggravated misdemeanor. On the third offense in the governor's bill, it goes up to a misdemeanor. The fines are fixed. I think they start at about $1,000 and they go up to $5,000. That's the kind of general. And I believe very, very strongly that it's not enough just to suspend the license. Those who participate in these activities, I took a different approach, not just punishment for their activity, but also requiring them to register their vehicles, which again, for those who convert these cars, would give us an opportunity to see who's out there converting these cars illegally.
Thank you.
You're welcome.
Any other questions for the author? Senator Calzert.
Thank you, Senator Jones. Appreciate you bringing this. I know it's quite a problem in Atlanta these days. Some of us have been getting a deluge of emails and phone calls that this is a racially targeted bill or racially discriminatory. What are your views on that? I want to make sure we're not going there.
Mr. Chairman, thank you for that question. I've gotten some of those same emails as well. And I think those emails were targeted at the original bill. It had some impounding language in it. It also has some fixed fines. I've listened to essentially everyone on both sides of this argument, those in the civil rights community, also the criminal defense lawyers, and this bill has been revised about 5 or 6 times. And that language has been removed, has given the judge's discretion with the fines, which the criminal defense lawyers asked for, and I've tried to accommodate all the concerns and questions that I've heard.
Are you comfortable that this doesn't unfairly target African Americans for enforcement or punishment?
Oh, absolutely. I mentioned to someone who asked me that question about the license plate. I said, I've been profiled before by police, but never because of the license plate on the back of my car.
Thank you.
Senator Watson.
Thank you for bringing this bill. Appreciate it. Just a couple of questions. I missed the part. The governor's bill or the House bill, they lose their license. Is that right? In this bill, they don't lose their license. They get points on their license, or I'm a little confused.
That is correct. Under the governor's bill, the first offense is essentially an automatic suspension for a year. Again, they mirror the DUI laws. And there, on the third offense, goes up to a felony. With my bill, I raised the points that you get off your licenses, and those are from 4, 6, 8, first offense 4.
Gotcha.
Second offense 6, and third offense 8.
So they can continue to be productive citizens, so to speak.
That is correct.
Okay.
And hopefully we can rehabilitate that behavior.
I understand. And getting at the people who do the conversion, I mean, they know they're doing it, the conversions for illegal purposes. I get that point. The other issue is the Section 10. That just doesn't seem to be fit in this bill. I'm just a little bit out of loss. What's the thought process on that?
Section 10, again, was an added section because in addition to any illegal activity surrounding cars, there's also just as much activity using ATVs on our streets and highways. So this bill does target those. And
so are you talking about people racing ATVs on highways?
They're racing them, they're doing donuts, they're laying tracks, all on ATVs. If you Google ATV street racing in Atlanta, you'll see all kind of videos out there, this kind of behavior, where they actually shut down the roads.
You know, I'm looking around the Judiciary Committee, and I think there are only maybe 2.5 rural guys here. And I'm not really rural. I'm from Savannah, but I have Bryan and Liberty counties, and I grew up in a rural area. And the ATVs I see there, they're the farmers that may cross the highways going to check on different fields. That's my only heartburn I have, with that. And I don't know how to get around that. If you're racing ATVs, or drag racing, doing that kind of thing, and that's crazy. But I wouldn't want to catch the farmer who crosses the road going to check on the cattle.
And I agree with you, Senator, and neither do I, by the way. That's why I created a unique section under Section 10 with a separate code.
Is that what that is?
40.7.4.1, but I also left under Section 11 the existing statute regarding the use of ATVs on highways.
Is the highway defined as a state highway and not a local road? Do you know the answer to that?
That is correct.
Okay. Do you have anything else, Senator Watson?
No, I mean, I need that comfort level that this is not affecting the vast geographic area of our state and solving a urban issue. Maybe I'm wrong. And maybe Senator Tiller can help me out here. He's probably more rural than I am.
Senator Tillery.
Thank you, Mr. Chairman. Senator Watson, my comment would be if they're entering on private property without express permission already, it'll be criminal trespass, which would be a misdemeanor already. So I don't think you're creating a new crime there. They may be able to be cited for a different purpose, but
It's already a misdemeanor as well as an operating a four-wheeler on a highway in the state.
I'd certainly hear your concern if another member of the committee has an idea on how to address it. But I do not think that the private property part doesn't bother me because they already would be committing. Senator Couch does a whole lot more criminal law than I do, but I think they already would be committing criminal trespass. So.
No graduation in that.
And I think down in section, if I can just read this section down on line 243, those ATVs, and this refers to the ATVs, that any person who violates any provision of this chapter shall thereby be guilty of a criminal act. So I'm not criminalizing, and this is already an existing statute regarding ATVs, someone who uses them on private property that without permission or highways or byways. I'm only capturing those ATVs as using the act of racing and drag racing and land tracks.
Who pushed the button down? Y'all are all sitting together as a group. Is it Senator Hatchett or Senator Kennedy? One of y'all pushed your button? Senator Kirkpatrick? Okay. Oh, all the way on the end. Senator Kirkpatrick.
Thank you, Senator, for bringing this bill up. I think I said this in the subcommittee, but with a daughter that lives in Midtown, I hear about this a lot. And we've all heard a lot about it all over the metro area for sure. There was a lot of conversation at the subcommittee hearing about the impound versus forfeiture of the vehicle. And from what I think I heard you say, you changed the not impound, the other word, forfeiture to with a conviction. Is what else changed about that? I missed that.
That is the only thing that changed regarding forfeiture, that you can only forfeit a vehicle. I also put in an escape clause for the forfeiture provision, that if someone essentially transfers the title, it gives them a way out.
Okay.
And this mirrors some of the other statutes that we have on the books.
Thank you.
The governor's bill has forfeiture in it as well.
Any other questions from members of the committee? Senator Hatchett?
I just did a quick research to answer Senator Watson's question. On line 235, it says, except as otherwise provided for in Code Section 40-7-5. 40-7-5 actually allows local municipalities and counties to allow ATV use on roads. And so that would solve that issue. Yep.
That was good, especially for a freshman.
Thank you.
Any other questions from members of the committee? Senator Rett?
No, at the proper time, I'd like.
Hold your thought. Anybody else want to be heard on the bill? Senator Hatchett, would you like to be recognized for a motion?
Oh, yes. I'd like to make a motion to pass.
Senator Rett, would you like to be recognized for a second? We have a motion to pass by Senator Hatchett by committee substitute, and a second by Senator Rett. Any discussion? All those in favor of the motion, please raise your hand. Any opposed? Passed unanimously.
Thank you, Mr. Chairman and members of this committee.
The next bill on the agenda is Senate Bill 155. Senator Gooch.
Howdy. Can I come up and sit with y'all?
Don't get too comfortable. We're working off LC 392868. Is that what you have?
That is correct, Your Honor.
I hope not.
The
floor is yours.
The last Judy chairman became a judge. So
yeah, they say
your
it's a
future-
stepping stone
your
now, I
future's
guess.
bright.
Yeah.
Thank you for this opportunity to come before you all, and I know it's late in the day, and we want to move
through your agenda as soon as possible. I will be brief with my comments. I feel like the referee at a soccer game. I'm about to drop the ball out in the middle of the field, and both sides are going to attack it. So this bill deals with the use of seat belts and the admissibility of that evidence in court, in the civil court proceedings. As you all know, seatbelt use is the most effective way to save lives and reduce injuries in car crashes. It's just common sense. If you look at some of the statistics, buckling a seatbelt costs nothing and it takes just a few seconds, but the failure to do so can generate enormous cost to both lives and property. According to the Department of Transportation, unbelted vehicle occupancies die in crashes at a vastly disproportionate rate. In 2012, unbelted occupants accounted for only about 9% of Georgia motorists, but a whopping 40% of the fatalities on our roadways. When unbelted occupants survive collisions, they experience much worse injuries. As the Georgia Department of Transportation has explained, seatbelt usage is directly correlated with injury severity. In fact, hospital costs for unbelted motorists typically run 2 to 5 times higher than such costs for crash victims who wore their seatbelts. Georgia jurors today are precluded from hearing this evidence that a vehicle occupant had failed to buckle up. The person may have committed a crime by not having their seatbelt on, but that evidence is not admissible. Georgia's jurors, in my opinion, need to be allowed to learn the whole truth so that they may decide based on the complete evidence what recovery for an unbelted motorist should receive. And that pretty much sums it up for the bill. You've all seen this bill more than once. You've seen it on the floor of the Senate multiple times, so I'd be happy to take questions or yield to the other people that have signed up to speak.
That was actually going to be my question. Was it last session this bill was on the floor of the Senate?
I believe it was last year, correct?
Last year. And do you know if this bill is identical to the one that was on the floor last year?
There's no mention of damages or limits of damages in this bill. This strictly applies to the admissibility of the seatbelt evidence.
Okay, for the seatbelt portion is the same as what we had last year?
I believe it is.
Okay. Any questions for Senator Gooch? No questions at this time. We have other people that have signed up to speak on the bill. Mr. Philip Henderson, I think it says with Ford. Is that correct? You can come on down to the podium. You can stay where you are, Steve, if you want.
Thank you.
Good evening.
It is the evening now, isn't it?
I know. Yeah.
Can you hear me all just fine with my mask on? Is that all right if I leave it on?
Yeah,
Okay.
whatever you're comfortable with.
So I just wanted to thank you all for allowing me the opportunity to come here this evening and share my perspective with you on Senate Bill 155. So I'm a lawyer here in Atlanta. I've been practicing since 2013. And the bulk of my work is devoted to representing product manufacturers that have been sued in catastrophic personal injury and wrongful death claims. In particular, the majority of my work is devoted to representing motor vehicle companies like Ford Motor Company and Fiat Chrysler automobiles. I'm here today to talk to you about Senate Bill 155 because the current seatbelt law has a substantial impact on my day-to-day practice as well as the clients that I represent. So I was here today. I was going to go over kind of 3 points as to why I don't think it's fair that jurors aren't allowed to hear this evidence at trial. I'm going to condense that a little bit in the sake of time because I do know it is getting late and I think there are other people here that wanted to speak tonight. But as Senator Gooch said, jurors deserve to know the truth about what happens in a crash. And while this is true, I would say for any motor vehicle accident that ends up in a lawsuit that goes to a jury, I think it's particularly true for product liability cases involving auto manufacturers. So I'd just like to share a couple of fact patterns with the Senate subcommittee today that kind of highlight just how, to be frank, unfair it is to the manufacturers in trials. So in 2018, I was a part of a team that tried a case involving a rollover of a pickup truck. The trial ended in a mistrial, and it will be eventually retried, you know, whenever Georgia gets back to having civil jury trials, whenever that may be. But anyways, the motor vehicle accident, right after it occurred, the coroner came to the scene of the accident because there were, unfortunately, 2 deaths in that crash. And he took photos of the accident scene that clearly show both occupants in the truck had routed their seatbelts underneath their arm, and at least one of them were hanging out the window of the truck after it came to rest on its roof. So misusing a seatbelt in this way, routing it underneath the arm, we know that this allows greater movement during a rollover crash. So, you know, when you go to the carnival or the fair and you're in that ride that spins around and it pins you to the wall, it's similar in a rollover crash. The forces push the occupant to the outside of the vehicle. So obviously, if you're not wearing the shoulder portion of your belt, you're more susceptible to outward movement. So what does that mean? It means that you're going to sustain greater impact forces in the crash, and it means you're more likely for your head and your upper body to actually exit the window after it's shattered in a multiple rollover, and potentially have your head pinned against the ground by the frame rail of the vehicle, which is what our experts were going to testify to the jury is what they believe happened in this crash. But unfortunately, because of Georgia's seatbelt statute, as it currently stands, the jury was not allowed to hear this evidence. We were not even allowed to show the photos to the jury of the occupants hanging out of the vehicle with their seatbelts routed underneath their arm. As it currently stands, we're not going to be able to present that evidence again at the second trial, whenever that may be. And we think that that is unduly prejudicial, patently unfair. And we think the jury needs to hear that information. We think it's key information as to how and why these 2 vehicle occupants unfortunately died in this crash. So one other fact pattern on a case that we're currently working on right now. This case involves another rollover. It was a large SUV that was traveling down I-85. It goes off the road and rolled over a couple of times. There were 7 occupants in this vehicle. Luckily, 6 of the 7 walked away from the crash without any substantial injuries. However, one of the occupants that was seated in the 3rd row of the vehicle was ejected from the SUV through one of the rear side windows. They suffered a substantial and life-altering spinal injury, and they filed a lawsuit against the manufacturer of the SUV. So the plaintiffs allege, and will be telling the jury in this case, that the vehicle was defective and the auto manufacturer is responsible for injuries because 1, the side curtain airbag did not protect the occupant from being ejected from the vehicle, and 2, the glass should not have shattered in the way that it did during the rollover, again allowing the occupant to exit the vehicle. Now, there is undisputed evidence in this case that this occupant was not wearing her seatbelt. Because of the current seatbelt statute, we will not be able to tell the jury that the occupant who was ejected from the vehicle and has filed a lawsuit against my client, the manufacturer of this SUV, potentially seeking millions of dollars, we will not be able to tell the jury that we think she was ejected because she wasn't wearing her seatbelt. So these are just a couple of examples of how we see it in our practice quite frequently, that the seatbelt law prevents juries, really as Senator Gooch said it, from hearing the truth about what happened in the crash. I anticipate that some of the other people that are here today to speak in opposition to this bill, plaintiffs' lawyers who I see here and I actually know, Mr. Carroll, I've had cases with before in the past, Mr. Ashby, wherever he's gone. I anticipate that they're going to come before the committee and tell the committee that they think that it is unfair to their clients that evidence of them not wearing a seatbelt is shown to the jury. I would contend it's not at all unfair or unduly prejudicial. We're simply asking that the plaintiff be held accountable for their actions, which we do in several other ways in cases just like this. So a couple of examples. Motorcycle helmets. If a person is wearing a motorcycle and they get run over and they're not wearing a helmet in that accident and they file a lawsuit, the fact that they're not wearing a helmet is admissible at trial. Airbags. In certain vehicles, you can turn off the passenger front airbag. If someone chose to disable the airbag and that decision caused or contributed to that person's injury in a crash, the jury would be allowed to hear that evidence. Headlights. They may not be commonly thought of as a safety device, but headlights are in fact a safety device. They allow vehicles to be more easily seen on the roadway. If someone fails to turn on their headlights and they're involved in a crash that occurs at nighttime, the jury would be allowed to hear evidence that they did not have their headlights on. And the reason that the jury hears all of that evidence and why they should be able to hear seatbelt evidence is because we are a state that allows for apportionment. So in 2005, this very legislature passed OCGA 511233, which requires jurors in civil trials to, quote, consider fault of all persons or entities who contributed to the alleged injury or damages, end quote. The language is mandatory. Jurors are required to apportion fault for what contributed or caused the injuries. And we think whether or not a plaintiff was wearing their seatbelt directly goes to apportionment. So I thank you for your time here today. I know it's late, so I'll cut it off there. If anyone has any questions, I'm happy to answer them. Otherwise, I'll let these other attorneys who are here to speak on this issue.
You do have a question, Senator Parent.
Thank you. Thank you, Mr. Chairman. Thank
Sure.
you so much for being with us today. Quick question. It's my understanding, and correct me if I'm wrong, and also looking through the legislation for current law, that we do not mandate seatbelt usage in the back seat.
That's my understanding as well.
So tell us how you feel about that. So would you still argue that even though we don't actually require people wearing seatbelts in their back seat, that it should still be the same analysis for front seat versus back seat riders?
Sure. There are plenty of acts that people can commit that are considered negligent that would give rise to claims for negligent that are also, they're not criminally liable, right? So you can take an act and be sued for it, and it doesn't violate any criminal statute, but you were still negligent, right? So it works the same way with apportionment. You don't have to have committed some sort of crime or violated a law in order for apportionment to be something that the jury considers. We think that it is reasonable for a backseat occupant to wear a seatbelt at all times, and to not do so, we think, goes towards fault, regardless of whether or not it's a crime.
Senator Cowser, question?
Chairman, we've got several non-attorneys, although they're extraordinarily bright non-attorneys on this case, this panel that may not understand exactly the relevance here. I mean, can you walk us through proximate cause? It's obviously not a cause of a collision.
Right,
but it could, just explain how it's relevant in a jury trial.
Sure, so a jury doesn't have to just decide who is at fault from a liability standpoint, right? They have to decide who is at fault for the injuries, and they're required to apportion fault for what causes the injury. So you may not be responsible for causing a crash, but you may be responsible for what happens after the crash, right? So not wearing a seatbelt or not has nothing to do with whether you were liable for causing the crash itself, but the nature and extent of your injuries obviously can be affected, as Senator Gooch gave the statistics, is directly affected by whether or not an occupant's wearing their seatbelt. So it's two separate considerations, which I think is what you were trying to get to.
In that type of case, would you have to have some evidence that the failure to wear a seatbelt added or contributed to the injuries or worsened them?
Yeah, I missed the first part of that.
In a case where somebody fails to wear their seatbelt, would you have to have some evidence at that trial? Say you could put in they didn't have on a seatbelt. Would you have to show that the lack of wearing it added to or caused or increased their injuries?
Absolutely. We wouldn't just be throwing this evidence at a jury without any reason for it, without any causation. Obviously, it would have to be a situation, just like all evidence, that there was that it was relevant for the purposes of showing why and how they were injured.
Thank you.
Any other questions? Senator Tillery.
Thank you, Mr. Chairman. Thank you so much for your comments today. I just have one quick little thing I jotted down. I can't remember if this will be a substantive or a procedural change. I just asked more directly. Would this change the outcome of a pending case? I think you said it's currently on appeal.
So it's not on appeal. It's in between trials. I would defer to the legislatures on that about whether this is a statute that is retroactive and applies to cases that have already been filed. I must admit I'm not an expert in legislative procedure in that regard.
So, but I guess right now then you can't opine as to whether or not it would affect even if it's in a different stage of trial, a currently pending or to be pending again case?
Sure. I mean, I would hope that would be the case, but I'm not familiar with the how the bill is written in that regard, or how the statute would go into effect. I'm a lawyer, but I'm not a legislative expert, so I would defer to someone else on that question.
Thank you.
Senator Kirkpatrick.
Yes, maybe I am asking the same question that just came up, but there's no effective date in the bill. And so, right, so theoretically it would be effective on the signature of the governor. Is that correct?
If he signed it, or when it become law otherwise.
So
Yeah.
then it would be effective for cases going forward?
My understanding, and somebody can correct me, unless it's written otherwise, it would be effective once it becomes law. And so if a case is tried after that point, you want to correct me? Mike, 9?
Yeah, absent an effective date, it would be July 1st.
But any cases beyond July 1st that are tried, would it come into effect in that case, is the question they're asking?
I can't speak on that, but I've seen language where it would say effective, this bill addresses cases
after that point,
on or after July 1st.
Yeah, if I may, I've seen other statutes in the Civil Practice Act that clarify whether or not it's affects current cases that have already been filed or not.
Right. Senator Hatchett.
Thank you, Mr. Chairman. As the law stands right now, is seatbelt use permissible evidence?
In a civil trial?
Yes.
No.
So you and the way this.
Wait. Are you saying it in reverse, right? If a plaintiff were wearing a seatbelt, would that be admissible?
Yes.
It's my understanding, and someone can correct me if I'm wrong, it's my understanding that seatbelt use, you're not allowed to discuss it at all. So
Okay.
A lot of times what you're left with is the jury just assumes they're wearing a seatbelt.
So the way this bill is written, violation of the code, evidence would be considered. So only evidence that you're not wearing a seatbelt. So in a case where there's a rollover and the roof crushes and everyone is belted, Ford would get the benefit, or a manufacturer would get the benefit, and the plaintiff wouldn't be able to present evidence that they were wearing a seatbelt?
Again, I'd have to defer to how the bill is written. I'm not sure how it's written in that regard.
I have one question. If I am injured in an accident and the issue is raised by the other side, whether or not I had my seatbelt on, how do I prove that I did?
That's a great question. So there are a lot of ways you can prove that you were belted in an accident. The most common way is through what's called an EDR, right? So every vehicle manufactured after, it depends on the manufacturer, 03, 04, 05 is when they started incorporating EDRs widespread into vehicles. There's essentially like a black box in a car, and it records all sorts of data from when a vehicle is involved in a crash. All of those in modern vehicles will tell you whether or not someone is belted. So that's the easiest way. For older vehicles, there are other ways to determine that. The most common way is to look for abrasions on the person themselves, right? So if you're in a substantial crash and you're wearing a seatbelt, it's going to leave bruising or abrasions or something on your waist where the seatbelt is. If it's a vehicle that is equipped with a seatbelt pretensioner, which is another safety device that when you're involved in a crash and the forces are substantial enough, with your airbag deploying, there's also a small explosion in your seatbelt that actually locks the seatbelt in place. Those have been around for a long time. And obviously if your seatbelt pretensioner deploys, that'd be something that any investigator can look at after the fact.
So it is different based on how old my vehicle is, and also it sounds like I have to hire an expert to deal with the issue in the case as well.
Not necessarily. I think any mechanic can look at a vehicle that was involved in a crash and tell you whether or not the seatbelt pretensioner deployed. Evidence of bruising or abrasions, that's not going to require a medical expert. There'll be photos of it, or they'll be in the medical records, or you could testify to it under oath. I had, bruising or abrasions along my waist.
So if the defense hired an expert, I'd have to hire an expert, I'm assuming, to rebut what they present, correct?
I've never had an expert who's come in and testified when there was a pretensioner that had deployed or someone had abrasions along their waist, or, you know, they're not going to come in when there's evidence of seatbelt wear and try and testify otherwise, right? It's pretty obvious when someone's been wearing their seatbelt and it's, you know, they've got credibility concerns for their own career.
And they get the EDR in, would I not have an expert to get that into evidence at trial, the evidence of that?
No, again, a simple mechanic can perform a download of an EDR. When you take your vehicle into, you know, a service station and they're pulling fault codes, it's a similar process. You just hook a machine up to it and pull the data off of it.
Senator Cowser.
I was going to offer a partial answer to Senator Hatchett's question. This statute as drafted does not limit the admissibility only to a plaintiff. It lists the areas, the issues that it can be relevant for. It doesn't say only on behalf of a plaintiff. Now, on the damages end of things, you know, that could generally go towards the plaintiff, but it also says negligence, comparative negligence, contributory negligence, and causation. So that rollover example that Senator Hatchett just got, if you know, if your head gets crushed in the accident and I'm the plaintiff in that case, I could show that it was caused by that roof caving in. My person's seatbelt was on. I would imagine this doesn't limit it to one party or the other.
Senator Watson.
Let me just understand this. I practiced medicine, worked in emergency rooms years ago, still go to the emergency room. And I have patients that have the seatbelt contusion, sort of obvious. You don't have to be a rocket scientist to figure that one out. So if I'm struck by a person, I'm in my car, they lose control, and they're not wearing a seatbelt, and I'm using that steering wheel to hold on for my life. I'm not, you know, whereas if I have my seatbelt on, I'm using that steering wheel to get back in control of the car. But if I'm skidding or hit that water and I don't have a seatbelt on, I'm using that steering wheel to hold on to. And they hit me, so it's sort of obvious that the person who's not wearing the seatbelt is, I mean, I don't have much sympathy for that person, you know, and I guess that's maybe what the fear is. But goodness gracious, I mean, he or she should have been wearing a dang seatbelt to keep from hitting me. I don't quite understand that logic.
So
why would you not? I mean, that's just, you know, for somebody not to do that. I don't quite get that.
So I think I'm following your hypothetical here. And in your hypothetical, you're involved in a crash. It was clearly someone else's fault, and you are not wearing your seatbelt, but you're bracing on the steering.
No. So
okay.
the person driving loses control. He or she doesn't have a seatbelt on, and they're skidding. They've lost control. They're not trying to. If you're not wearing your seatbelt, you're not trying to get back under control. If you're wearing your seatbelt, you're planted in the seat, and you're trying to steer to get back into control. That's sort of my issue with the not wearing your seatbelt. Am I wrong on that, or?
I'm still not quite sure I'm following your hypothetical, but let me say this, because I think this can clear up the confusion. The seatbelt evidence or lack of wearing a seatbelt evidence doesn't go towards who is at fault for the crash, right? It's going towards what caused the damages. So there's really two aspects to a civil trial, right? You have to decide first who is at fault, and then once you've decided who is at fault, what are the damages. So the seatbelt evidence that I've been discussing today, the lack of seatbelt evidence, is frequently going towards who's responsible for the damages. So you may have been involved in a crash that wasn't your fault, but had you been made the choice to wear a seatbelt, your injuries and damages would have been lessened. So you still recover, but your recovery is less. Does that answer your question?
I think it does. I guess it has to do with more civil, you know, where's wearing the seatbelt. I got you.
Sure.
Okay. That helps. Thank you.
All right. Thank you, Mr. Henderson.
Thank you very much.
We have other people signed up to speak. Mr. Humphrey, Nathan Humphrey with NFIB. Is Nathan still here? Yeah. Come on up.
Thank you, Mr. Chairman, members of the committee, and for your time checking up this important bill. Just like to point out, just to save time, the broad spectrum of business and industry that supports this bill. Big business, Georgia Chamber, NFIB, small business, Home Depot, and your local hardware store, and everything in between. So it has very broad support. And since we have gone through this exercise last session, other states have passed similar legislation dealing with this issue. Most notably, like off the top of my head that I can remember, is Louisiana has just recently passed this statute. And I'll just say, as it's already been pointed out, that there's ample evidence that wearing your seatbelt does save lives and lower physical damage in a car accident. We know that as a fact. No one disputes that. But 97% of Georgians wear their seatbelt consistently. Yet that 3 to 4% that don't make up the majority of fatalities and severe injuries. So that percent is what we're talking about in that universe. And there's significant costs involved in that. And all we're saying is that if we trust juries, we should be able to show them that evidence. And in the midst of all that, the lawyers on both sides will be able to litigate that evidence and the merits of that evidence. But they can't do that if they're not even allowed to show that. So that's all that we're asking for in this bill, and appreciate your consideration time.
Thank you. And let me just say what I probably should have said before we started on this bill. It's 6:30. I will stay as long as the committee wants to stay. We have 3 other bills after this we're going to hear. At the same time, if we get where people have to leave and we lose a quorum, everything we don't get to today is going to be Friday after adjournment mixed with other bills, which, as y'all know, keeping a quorum then is going to be difficult. So I'm going to talk to myself as well and encourage us to try to obviously spend the time we need to spend on these bills, but to be as brief as possible so we don't kill other bills in discussing this one. No questions now. Senator Kauser.
And I'd be killing my own bill, so I wouldn't ask unless I thought it was important. Do you know how many other states allow this type of evidence?
I do not, Senator. I do know that in the last time that we have had this debate and discussion, that other states have passed it since then.
Okay, thanks.
Senator Tillery.
Thank you, Mr. Chairman. Just two things. One, the question for Mr. Humphrey, but also want to point out, Senator Watson, it does look like this evidence would be able to be used for causation. If you look at line 16, it's now permissive use or causation was added. But Mr. Humphrey, my question would be, if you look on line 17, it looks like there used to be a provision that prohibited using this evidence to increase insurance rates. Are your members at all concerned that this might actually be a backdoor way to raise insurance rates now?
I'm not aware of that section or the history of that, Senator. But insurance rates is a very big concern for my members. I think looking at the history of this in other states, in our surveys, though, with our membership, they would be very much in support of this.
You might want to take a look at it. Strikes that in line 17. Just wanted to point that out. And
okay.
Raises a little concern for me.
No other questions for Mr. Humphrey. Thank you for your time. Thank you for sticking with us tonight. One other person signed to be heard on this bill, Drew Ashby with GTLA.
Thank you, Mr. Chairman. And I do note that I'm the first person to come up and speak after the admonition to keep it short, and so I'll do my best to do that. I have, when I prepared for this, I typed out about 6 pages of testimony, and I've since culled it tremendously. My name is Drew Ashby. I'm the owner of the Ashby firm. I do a lot of personal injury cases, a lot of which are in the product liability realm. Mr. Henderson and I have cases together right now. Although I don't think it was intentional, I appreciate the committee recognizing something that I intended to come up here and talk about first, which is that Ford Motor Company came here in an attempt to effect ongoing litigation. Which is, I think, something the committee should take note of, and it's something that's deeply, deeply troubling to me. One of the things I did in an attempt to understand better what this bill was going to do and how different states had addressed these issues before, and there's wisdom in looking at how other states have addressed these issues before, is that I painstakingly sat down last night and I took this bill and I compared it to A, Senate Bill 148 in 2019, which I had the honor to testify before you about. That did not pass, it failed. And also Senate Bill 415 in 2020, which also did not pass and failed. And I compared it to this bill, which has already been noted, is virtually identical except for minor provisions. I then looked at how other states have handled this, and I discovered something quite interesting. 30 states have effectively the same law as Georgia. Georgia's one of the 30. 2 of those states, Ohio and Kentucky, courts allowed seatbelt evidence, and the legislatures then came back, overruled the courts, and disallowed seatbelt evidence. Ohio and Kentucky are now in that 30. If you look at all the other states and how they handle it, they handled a little bit of a smattering of different ways, all of which, except for one, restrict how the evidence can be used and what it can be used for. There is only one state in this entire country that allows for unfettered, unrestricted seatbelt evidence like this bill proposes, and that is the state of California. So the proponents of this bill are asking for this legislature to jump on an island with California in how we handle seatbelt evidence. The biggest problem that I think I have with this bill is that it shifts the focus from the person who caused the crash to the injured person who had nothing to do with it. That's wholly improper. And I'll tell you why. Because if this bill were to pass, and you can mark my words, a drunk driver who kills an innocent driver will get off scot-free in a civil case because one of those innocent drivers may not have been wearing a seatbelt. Let me say that again. A drunk driver who hits a car through no fault of their own will get off scot-free in a civil case because either the driver or passenger in that car were not wearing their seatbelt. That is the effect of what this bill will do. I understand Mr. Henderson's concerns in product liability cases. I appreciate them. I think they're unfounded for various reasons. But this bill is not limited in any way to product liability cases or any other kind of case. This is every case out there, including that very case against the drunk driver that I just told you about. We did go a little bit into this, and I'll skim over it as a result. This creates tremendous problems in litigation, drives the costs up, and creates inefficiencies. Imagine tonight your family member is rear-ended. Through no fault of their own, they're at a stoplight, and they are rear-ended. How are they going to prove under this new law that they were wearing their seatbelt? Because make no mistake, that's what this law does. It creates a new burden of proof for plaintiffs to affirmatively prove that they were wearing their seatbelts in crashes. Well, there's 3 ways to prove it. There's eyewitness testimony. We'll just call it, for the sake of argument, the black box data. And then there's biomechanical engineering evidence. I'll go through those one by one. Eyewitness testimony is going to be completely unreliable because the first thing you do if you're conscious or living after a wreck is you take your seatbelt off. And the EMTs and the first responders and the police often take minutes, 5, 10, 15 minutes to get there. They view you with your seatbelt off. First responding bystanders are there 30 seconds, a minute later. They view you with your seatbelt off. I'd like to tell you about 2 very brief cases that I handled where this issue came up. The first one occurred in Blue Ridge, Georgia. A young lady and her passenger with 2 kids in the back seat were rear-ended, and as a result, their seats that were defective failed backwards. Impact from the rear pushed them back in their seats. Seat backs failed backwards. They slid out of their seat belts. There was so much confusion in the car. As a result of that, by the way, a child in the back seat was killed when the driver's head struck her head. It was her niece. There was so much confusion after the incident and so much trying to get where they needed to be in the vehicle afterwards that the people who were there 2 minutes later who stopped and ran back, when I interviewed them, said they didn't know whether the occupants of the vehicle were belted or not. That evidence would have come out in this case, even though in that case the EDR showed that they were belted. The second case I handled was a seatbelt defect case where one of the eyewitnesses, one of the bystanders who was the second person to approach the vehicle after the crash, was going to state, had they testified, that the person was unbelted. And their reasoning for that was because the person was passed out receiving CPR on the side of the road at the time, and they didn't see him with a belt on. That evidence would have come in. It would have been incredibly prejudicial, and you cannot unring that bell with this kind of evidence. I will note that this bill provides different standards for civil evidence and evidence in a civil case and traffic citations, and you can see that towards the rear. I'd be happy to answer questions about that if you'd like. There's black box data, which we've talked about, which is horribly problematic, particularly at this time. I'll tell you why. A, it increased costs, as Chairman Strickland noted. I'm going to have to, in a case that may not have the value to necessitate it, I'm going to have to hire an expert, not just to download the black box, which will cost about $1,000, but to come back later and interpret that data. Now, Mr. Henderson said on behalf of Ford that that can be done cheaply by any mechanic. Well, let me tell you what a mechanic is called when they come and testify in a case. They're called an expert, and you have to qualify them as such. But usually those are not the kinds of people who do it. Here's the horrible problem with that. Until 2012, the black box data in vehicles is encrypted by the manufacturers. You cannot access it without a key from the manufacturers that they will not provide you. I've tried. Until you get into litigation, until you get a court to force them to do so. So I tried to do a little bit of research to show this committee what kind of problem that would be. And in July 29th, 2020, Car and Driver published an article on this very issue. And they said the average age of vehicles on the road is approaching 12 years. They say approaching 12 years because it's 11.9, which means at this point in time, were this bill to pass and these wrecks were to happen today, and there would be claims of seatbelt non-use, more than 50% of the vehicles on the road would be unable to use the black box data to prove that the person was wearing their seatbelt. Finally, there's biomechanical evidence. And all I can tell you about that is that you need a biomechanical engineer to talk about that kind of evidence before the jury, let alone assess it in the case. And the biomechanical engineers that we use in Atlanta are $350 to $450 an hour. And I'll tell you, we have it good in Atlanta because I have the honor of doing cases in other states in this country where we've paid upwards of thousands of dollars an hour for these biomechanical engineers. I was going to note an additional problem that I wasn't sure was evident from the face of the bill, and I wanted the committee to consider. And I was surprised to see Ford essentially concede this, which was that even if you're belted, that doesn't end the discussion. They're going to come along and say that you weren't properly belted, which is going to require you to hire a biomechanical engineer to talk about why that wouldn't have made a difference. So it's not just seatbelt use or non-use that's at issue here. It's whether you're effectively wearing your seatbelt according to a manufacturer or according to a defendant. I'll note a couple things in closing based solely on the arguments that have been made before here today. Y'all are well aware that the Governor's Office of Highway Safety says upwards of 98% of people wear their seatbelts. And so that this is, in our opinion, a solution in search of a problem. But the retort to that has been, there's a large percentage of people who don't wear their seatbelts who make up deaths and other serious injuries in the state. And so therefore, this is an issue in ongoing litigation. Well, here's where the gaping hole is in that analysis. We don't have any data as to how many of these people who are additionally injured are plaintiffs in injury cases or death cases. But I can tell you this, in the vast majority of my serious crash cases, the decedents are defendants in those cases. That is not indicative of an issue. And I'll tell you that if this were an issue, respectfully, there would be a parade of horribles shown to this committee about litigation after litigation after litigation where these were issues. And yet we've heard about 2 cases. The final thing that I'll address is that this prevents the jury from hearing the truth. Well, honestly, that's what the rules of evidence do. They determine whether there's something that's unfairly prejudicial that shouldn't be heard by the jury because of the consequences that can happen as a result of that. Here's what else the jury doesn't hear. The jury doesn't hear the citations that an officer gives on the scene based on their personal observations of what happened at the wreck. The jury didn't hear that either. That would be something that the jury should consider, but that is something they cannot consider. Finally, this isn't about seatbelt compliance. If it were about seatbelt compliance, there'd be more than a $15 fine. That's the kind of, when you look at the studies, the kind of enforcement that drives up seatbelt compliance is additional fines and greater enforcement of the laws and those fines. This doesn't have any motivating effect to anyone. The only thing it allows people to do is benefit when they shouldn't benefit from these. In other words, allow a striking driver to benefit against an injured driver or an injured passenger improperly in a civil case. There's more to say, and I've skimmed the top, but for the sake of time, I'll cut it there and take any of your questions, please.
Thank you. Any questions, Mr. Ashby? No questions. Thank you.
Thank y'all.
Nobody else has signed up to speak on this bill. Anybody else want to be heard on this bill?
Mr. Chairman, if I might.
Yes, sir. Step on up.
I apologize for somehow not signing up properly. My name is Ed Crowell. I'm with the Georgia Motor Trucking Association. And I come and I will briefly support this bill. I think it's obviously common sense. I think Senator Gooch started it off with the proper analogy. Quite simply, you've got a contest, and no one wants to play a contest on an unlevel playing field. And that is exactly what exists today. Mr. Ashby, I think if I ever need an attorney, I will hire him. Eloquent to the point of should be on television, clearly spent a lot of time in courts, clearly spent a lot of time arguing on his feet, clearly threw you a lot of straw men. Not the least of which is that the plaintiff is always the innocent victim. I'm here to tell you that the trucking industry is plagued by lawsuits, frivolous lawsuits, and that one of the many problems we have is this inadmissibility, where someone strikes our trucks, often when our trucks are sitting still, and then we get the lawsuit. And the driver isn't even wearing a seatbelt. Their injuries are compounded because of their own actions, but that evidence can't be heard in court. Mr. Ashby mentioned a parade of horribles. I could bring you truckers for a week and a half with story after story after story, if that's what the committee would like. It goes on daily. And I do want you to understand, when I say trucking company, you think UPS, FedEx, these big trucks, big companies. They're not. The vast majority of trucking companies have less than 20 trucks. They're small mom and pop operations. They're small businesses throughout Georgia. Their insurance rates are going through the roof because they're victims of frivolous lawsuits. And one of the problems, not the only one, but one of the problems is quite simply evidence a jury's not allowed to hear and not allowed to make a decision on. The law already says the jury should be able to assess some blame, some responsibility. To hide this particular piece makes no common sense. Again, I know it's late, and I apologize for taking more time, but I do urge you to support this bill. Senator Tillery, your point about the insurance rates increase, I think that's worth looking at, but I will tell you this bill would lower insurance rates for truckers. It would lower insurance rates for truckers if that evidence was allowed, because we pay some of the highest rates in the country right now here in the state of Georgia. So with that, I'll thank you.
Thank you, and I apologize. I don't have where you signed up, but I apologize. That's why I always ask at the end in case I missed something. So.
No, I think it was me. Sorry.
Okay. Does anybody have any questions? All right. Thank you. All right. This time, it'd be proper someone wants to make a motion.
Move to pass.
We have moved to pass by Senator Calzert. Senator Rhett, sorry, let me stop. Senator Rhett asked me to tell him when we were voting on the bill.
Yes, ma'am.
All right, we have a motion to pass by Senator Calzert. Do we have a second? Second by Senator Watson. Do we have any discussion? All those in favor of the motion, please raise your hand. 1, 2, 4. All opposed? 5. The motion fails. 5-4. All right, the next bill on the agenda is Senate Bill 160. Does anybody want to take a 5-minute break? I don't want to push you all.
Can I kind of inquire on the schedule? You had mentioned to me earlier today that my bills were last and I could defer them till Friday if need be. I sit here at 10 till 7 and I'm kind of watching. I don't feel like it's fair for me to keep everybody here, and I've got a couple of witness problems on some of these later bills. So I am fine with postponing until Friday. Will these be like at the top of your schedule Friday, or am I going to drop to the bottom of the line?
Honestly, I don't know yet because I've got to reevaluate what we have left in the committee. Obviously, you can make a motion to table the bills if that's what you like. The only thing I'd say is the committee members, I'm assuming, will be here regardless. It's just the people that come here to testify. I want to give some, I want to think about them as well. But if that's what you're requesting, I'll ask the committee if that's what we'd like to do. Senator Parent.
Mr. Chairman, do we know what time the meeting is Friday?
So, I mean, what we did is we requested any time we had left for another hearing, and the only time that we did not have conflicts with the committee we were given was either 6 o'clock tomorrow night, which I didn't take, or upon adjournment on Friday. Okay. And so I don't know how many bills are going to have on the floor Friday. So
thank you.
I'm happy for Friday then, because I think that'd be more convenient for people that like to testify.
Does anybody on the committee have any objection to that? Okay. Well, we have Senate Bill 160, Senate Bill 189, and Senate Bill 190, and I'll get with you, Senator Calvert, on the schedule for Friday then with those bills.
Thank you very much, Mr. Chairman.
All right. With that, we are adjourned. Thank you.